Hello, everybody. This is Steve Yoder. Welcome to the last 5 days in Legal Studies 457, 557 here in the spring of 2025 at the UAB Collat School of Business. This week, these 5 days, we will be looking at antitrust law, which is the law that helps protect competition. We'll be looking at how accountants and other professionals can be found liable in connection with their work, and we'll be looking at the very important topic of business ethics. Let's go ahead and get started. Here is last week's extra credit question. The PhD project is a project that has been in place for over 20 years, designed to get more minorities, particularly African Americans, into higher education, particularly into the world of business studies in higher education. The Department of Education is investigating those universities that have participated in the PhD project, including UAB, on the grounds that selecting participants in the project based on their race violates Title VII of the Civil Rights Act. That is a new way of looking at the purpose of the Civil Rights Act that is penalizing somebody potentially for trying to get a minority group, such as African Americans, more involved in a particular profession. The students who are in the Section 557 part of the course have a reflective memo due on April 28th, which is today, the day that I am releasing this recording. So you have to have that in by the end of the day. Let's look at antitrust law, Chapter 38. You could cover a lot of what you need to know about antitrust law just by looking at this law that's well over 130 years old now. It's a very short law. They used to write laws with fewer words than they do today. Here is the brother of the Sherman after whom this law is named. You may know the brother from his march through Georgia in the Civil War. This law is the greatest tool of the government in helping competition thrive in our business world. Think about what life would be like if we didn't have a law like this and there were monopolies in products such as this area. There are not monopolies, although there have been a few of these that have been accused of trying. There's been a great deal of attention to monopolies and why we don't want them. Here are a couple of examples. The NCAA was found to be a monopoly 4 or 5 years ago by, at the time, limiting schools' ability to compete for player talent. Here's another example. Visa has been accused of being a monopoly in the debit card business. 30 years ago, Microsoft was accused of being a monopoly because they would bundle their own browser into their software and would block any other browser. 30 years later, the government is accusing Apple of being a monopoly for denying its rivals access to key features of the Apple iPhone, like the ability to pay using a chip inside your phone. Here's another example. Microsoft may have to separate Teams from Outlook and Microsoft Office because it's doing so could be considered monopoly behavior that reduces competition. Very much in the news right now is the lawsuit against the parent of Facebook, Meta. The government is accusing them of buying WhatsApp and Instagram only to hold down competition from them. Google had a very bad week in a couple of weeks in April within a period of about a week or two, two different federal judges found different ways that Google was acting like a monopoly. The Sherman Act is not the only law that will perhaps come into play. Monopolies can be created in a number of ways. One way they can be created is by two companies that do not have monopolies merging and creating one company that does have a monopoly. The Clayton Act was passed to stop those situations before they happen. There have been a great deal of, there's been a great many airline mergers that have been allowed to happen, even though you could say there's a lot less competition as a result in the airline industry. The government sued Albertsons and Kroger, do not operate in Alabama, sued them from doing the merger that they wanted to do, and the government won that. Eventually, they made it so difficult that that Kroger at least bailed from the deal, and Albertsons is now suing Kroger. What will life be like under the Trump administration? The predictions is that there will still be antitrust enforcement, but it won't be, quote, hipster antitrust like in the Biden administration. I'll let you Google that and decide for yourself what hipster antitrust means. How can accountants and other professionals be liable? It's a very important topic for all of you. You don't want to be liable. You don't want to be sued by your clients or others. One way you could be found liable is if you've entered into a contract with your client, say to do an audit by a particular time, and you don't live up to the terms of the contract. That's a breach of the contract. Another way is to be negligent in the way you do your work, and often the way that negligence is shown is by violating generally accepted accounting principles or generally accepted auditing standards. Here's a prime example of negligence. Ernst & Young in Europe failed to confirm bank balances of the company Wirecard, and by not doing that, they failed to spot a very large fraud going on. Here is another source of liability for accountants. If the accountants themselves help engage in fraud, they can be found liable for that, potentially in a criminal way. Congress was not satisfied with the accounting profession's ability to find fraud in its clients, so it created the Public Company Accounting Oversight Board. Those of you in the Section 557 part of the course know what the PCAOB does in that regard. Accountants can be found liable under a whole separate set of rules if they are in the tax return business. And a tax return preparer is someone who does that for compensation, which presumably you as a CPA will do. Accountants, unlike lawyers, if they are called to court to talk about their clients, probably will have to talk about what their client said to them. The law of privileged communications for accountants is far less widespread than is the case for lawyers. The American Institute of Certified Public Accountants has a code of professional conduct that you all should know about. There's a great deal of activity in that area about taking and giving up and what you do with client records, client files. You can expect there to be a question on my exam and on the CPA exam on that topic. Just recently, the AICPA added a new section of the Code of Professional Responsibility for CPAs regarding disclosing the answers to the CPA exam. Don't do that. Stop and pause and look at this. Finally, Chapter 3, what are business ethics? Business ethics are a subset of the general moral principles that we should all be following in our behavior in society, applicable just to the business profession. Most companies, particularly large companies, have a ethical code of conduct. They often have 3 common elements that you can see here. Some go a little bit further, like Costco would add a 4th one, which is be good to our vendors. Walmart does not have that one in its code of conduct. How do you reason through an ethical problem when one presents itself to you? There are many different ways. Choose one and just stick by it. One way would be to use what are called duty-based ethics. Find a code like the 10 Commandments and follow it. The Hippocratic Oath, above all, do no harm. It would be another example of duty-based ethics. Here's one in your textbook that hint for those of you who've gotten this far or looked at this video at all. This will be tested on, or this will at least be in the pool of questions for the 3rd and final exam. Here's one: I desire to do right. Stop and pause and look at that as a way to reason through an ethical problem. Here's a real-life case that involved some unethical behavior. There's also a question in the pool in the 3rd exam based on this case. Here's a real-life example of someone who violated his employer's code of ethics in what you might say is a very small way, ordered dinner for his wife and just charged it as dinner for himself, and Citibank fired him for violating the code of conduct of the bank. The CPA exam from now on is supposed to be covering the Foreign Corrupt Practices Act, which was passed in 1977 to prohibit bribery of foreign officials and also to make sure that books and records were accurate. Didn't call a bribe something more benign than that, but the words they used for for public companies to have their accounting records be right in that regard goes much beyond just how you characterize bribes. So here's a little bit of guidance on what would be considered a bribe. Intent is the key. You don't have to say a word, but if you hand some cash over to a foreign official, that could very well be considered an illegal bribe. There are exceptions for so-called grease payments, but these have to be very small amounts of money to very low-level officials in foreign countries. Here's an example of a case against a well-known company, 3M, fined a lot of money back in 2023. But that was then, and this is now. President Trump took office, and within 2 weeks of taking office, he issued an executive order that paused the enforcement of the Foreign Corrupt Practices Act. I think you're still going to see this tested on the CPA exam, but after that pause by the United States, the countries shown here, England, France, and Switzerland got together and created a task force to look at the very issue that the United States had just paused its efforts in. Here is the section of the securities laws that gets at making your books and records correct. The Big Four accounting firms take ethics seriously. Here is a course that you can take at KPMG, or at least you could at one time. More on that in the learning module. Let's go back here. For 2 points added to your third exam, here's your last extra credit opportunity. Tell me by Friday night, May 2nd, what accounting firm in April of 2024, about a year ago, received the largest fine ever imposed by the Public Company Accounting Oversight Board, and tell me briefly why that very large accounting firm was fined. Tomorrow, Tuesday the 29th, everyone has to take this short survey. No right or wrong answers. You can only give one answer. If you give me more than one answer, you're not going to get full credit. And there will be a question on the third exam based on the results of this survey. So you've got to take the exam, and you've got to then look at the announcement that I send out about what the results are. So here's our calendar. Today is Monday the 28th of April. The reflective memo is due for most of you. Tomorrow the survey closes and must be taken on professional responsibility. Wednesday, the last set of CPA client consultations must be done on VoiceThread and completed by 11:59 p.m. At 5 o'clock that same day, the third exam will open. It will cover everything in the third learning module. Be sure you read the instructions carefully on that exam, and that exam will close at 11:59 p.m. on Friday, May 2nd, which is the last day of this course. And after that, the course is over. It's been a pleasure having you in this course, and I wish you all success personally and professionally.